Hello, welcome to the second part of the Cyber Law and Ethics video for the CMU Gen Cyber. In this video, we will talk about international law as well as ethics and case studies. But if you haven't watched the first part, which deals with domestic law, I highly recommend going to the first part of the video first and then coming back to the second part. So in international law, we will deal with international actors and introducing different actors in the international law space, and then moving on to talk about cyber warfare. So again, some disclaimers. One, this material is up to date with up to March 2024, but the legal and political landscape are frequently changing. So if you ever watched this video a few years out, please note that some of the material could need updating. And the second part that I want to point out is that the goal of this video is not to tell you what is right or wrong, but to provide you with some frameworks for making these decisions yourselves and inspiring these discussions in your classrooms. So please remember that multiple opinions are possible in these topics and issues, and I am not trying to influence a specific decision. So going over to the international actor space. First, this is probably the actor that we are the most familiar with, but the United Nations or the UN. The UN is the world's largest international organization, and according to its website, it is a one place where the world's nations can gather together, discuss common problems, and find shared solutions. The UN was established in 1945 after World War One or after World War II with the aim of preventing future world wars. It succeeded the League of Nations, which was established after World War One. And there are at the moment 193 member states, 193 member states in the United Nations, and the United Nations is guided by the founding charter, including the preamble that you may have often read about. The UN is structured as six principal organs. It consists of the General Assembly, or the GA, which is the main organ. This is composed of representatives from all member states with one vote per member state. There is also the Security Council, or the SC, which main goal is to maintain peace and security. It is composed of 50 members with one vote per member. And then we also hear about the Economic and Social Council, the Trusteeship Council, and the International Court of Justice, or the ICJ, which is the principal judicial organ for the United Nations, and the UN Secretariat, who deals with day-to-day administrative work. And there have been cyber-related efforts by the UN. For example, one example is the UNOCT, UNCCT Cybersecurity and New Technologies Program, and this was led by the UN Office of Counterterrorism, or the UNOCT, adopted in April 2020, and this basically aims to enhance the capacities of member states and private organizations in preventing cyber attacks. There's also the United Nations Cybercrime Treaty that is currently in negotiation, and they aim to finalize the text by 2024. So one interesting thing to discuss in your classrooms is what are cyber efforts that can be carried out at a global scale? So what are the different efforts that you think that needs to be cooperated and agreed upon internationally when it comes to cyberspace? So we talked about how the UN was trying to push for a cybercrime treaty, right? So what are treaties and what are international agreements? So the treaty is the main source of international law, and it serves as a major mechanism for international cooperation. And there was even a convention on the law of treaties in 1969 in Vienna, and it defines treaty as the following: an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. An agreement is usually less formal than a treaty, and whether it is treaty or agreement, you will commonly hear the phrases bilateral or multilateral that denotes the parties involved. So a bilateral agreement or treaty would be between two countries, multilateral would be between three or more countries, international would be more on an international level. There is also the North Atlantic Treaty Organization, or NATO, and this is an intergovernmental military alliance. And one key idea behind NATO is collective security. In Article 5, member states agree to defend each other against third-party attacks. NATO was also established after World War II, but as you saw, the military alliance has quite a different purpose and implication than the United Nations. It was established in 1949, and currently there are 32 member states, also called NATO allies, which consists of 30 European and 2 North American countries. As you can imagine, the 2 North American countries are the United States and Canada. Recently, Finland joined in 2023, and even more recently, Sweden joined NATO in 2024, and it implements the North Atlantic Treaty. You can see a list and the flag of the NATO countries and when they joined NATO in the picture on the right. So I talked about the Article 5 of NATO. If we read into the article, it reads, the parties agree that an armed attack against one or more of them in Europe or North America shall be considered an attack against them all. And consequently, they agree that if such an armed attack occurs, each of them in exercise of the right of individual or collective self-defense. So the idea of collective self-defense is really crucial when it comes to NATO. And what's more interesting is that they recognize that the impact of significant malicious cumulative cyber activities might, in certain circumstances, be considered an armed attack that leads the North Atlantic Council to invoke Article 5 of the North Atlantic Treaty on a case-by-case basis. So we begin to see the significance of cyber attacks when it comes to, NATO and collective self-defense. It's not quite certain what significant malicious cumulative cyber activities mean. What is the threshold? But cyber attacks are being considered in Article 5 of NATO now. And some cyber-related efforts by NATO includes the 2016 Cyber Defense Pledge that pledges to ensure that the NATO keeps pace with the fast-evolving cyber threat landscape and are capable of defending in cyberspace as in the air, on land, and at sea. So this is a pledge that pledges to expand the cyber defense capability of NATO. And in 2023, NATO launched the Virtual Cyber Incident Support capability, which supports national mitigation efforts in response to significant malicious cyber activities. And you can see other NATO documents relating to cyberspace on the right. Another organization that I want to bring up is the Five Eyes. So this is an intelligence alliance comprising of Australia, Canada, New Zealand, the United Kingdom, and the United States. And you can see that there is indeed international cooperation in cyberspace. One example is the Operation Shrouded Horizon in 2015. This was an 18-month international law enforcement investigation that involved 20 countries. And this basically targeted Darkcode, which was an online forum for buying, selling, and trading data and software that facilitated cyber crimes worldwide, such as malware, botnets, stolen personally identifiable information, and even credit card information. And this resulted in charges, arrests, and searches involving 70 Darkcode members and associates globally. And this operation involved 20 countries. So you can see how international cooperation is sometimes necessary, given that the nature of cyber crimes can be quite international and globally carried out as well. So moving on to cyber warfare, I want to point out two concepts, jus ad bellum and jus in bello. So jus ad bellum is the Latin for the right to wage war, and it basically refers to the conditions under which states may resort to war or to the use of armed forces in general. And Childress lays out 7 criteria into considering when states have the right to wage war, and this includes legitimate authority. The war shouldn't be just declared by a normal citizen like me, but it should be declared by, for example, the head of the state. a just cause. There should be a just cause for waging war, right intention, announcement. You can't launch a surprise war attack, but you have to announce the war in advance. Last resort, you should try other methods to avoid waging war, reasonable hope of success, and proportionality. And when it comes to jus in bello, this is the Latin for the law in waging war, and this refers to the conduct of parties engaged in an armed conflict. So Oren lays out 6 rules, including obey all international laws on weapons prohibition, discrimination, and non-combatant immunity. What this basically means is you need to minimize harm to civilians, to non-military people, non-combatants. Proportionality, force not exceeded what is needed to accomplish a military goal. And also benevolent quarantine for prisoners of war, and no mala in se, so you can't do something that is by fundamental nature malicious, such as rape, genocide, and so on, and no reprisals. And when talking about cyber warfare, I think the first thing to discuss is the definition of cyber warfare. And can we actually call it a cyber warfare? And perhaps war is currently a strong word because until now, cyber attacks have not reached the level of destructive magnitude as traditional warfare. However, we do see growing sophisticated cyber attacks by nation-state actors, or whom we call advanced persistent threat APT groups. And there are different types of cyber attacks and operations that can be categorized into the following. There are destructive attacks that aim to permanently delete data or damage services. There are disruptive attacks, which aim to cause disruption of services and operations, such as bringing down a server or a network. There are espionage, which is spying for confidential information or for potentially useful information. There's also disinformation, misinformation, degradation attacks, and so on. So a classroom idea would be discussing how is cyber reshaping international and domestic conflicts, and talking with students about how cyber attacks and cyber warfare are changing the way we view international relations. So kind of continuing the topic about cyber warfare, how is cyber warfare similar or different from traditional warfare? One key point is that attribution of cyber attacks is pretty difficult. If you bring a tank to another country, if you launch a missile attack, it is fairly easy to attribute where it is coming from and who did it. Versus cyber attacks, it's hard to attribute who this is coming from. Is this actually coming from a nation state actor or more of a civilian, someone who's acting outside in their own accord? So attribution is pretty difficult given the nature of nature of online activities. Also, some people call it one-time use, but if you look at stuff like zero-day vulnerabilities, these unless the other party decides not to apply proper security patches and updates, are mostly one-time use. You can't use it again because people know what the vulnerability is that you exploited and they can patch it up. So cyber weapons or cyber attacks are sometimes or often one-time use. And there's also asymmetry. You don't need as much resources to launch a cyber attack. It's often cheaper and requires less resources to launch a cyber attack compared to having aircrafts and tanks and a whole army of personnel. So there is the asymmetry factor to cyber warfare. And finally, we talked about how it hasn't so far caused as much destructive damage as traditional warfare, but it can be combined with kinetic military operations, traditional military operations, to have an even more significant impact. So another question that you could discuss in your classroom is traditional international law adequate to address cyber attacks and cyber warfare? What are some gaps and what are some things that aren't already addressed? For example, we talked about discrimination and non-combatant immunity, not targeting civilians. Well, what about in the case of civilian hackers? Are they considered combatants or non-combatants? And What about attacks on critical infrastructure? Because that cyber attacks on critical infrastructure, because that affects civilians. Another thing would be to talk about proportionality. Um, when is the threshold for NATO to trigger Article 5 for cyber attacks? Because we shouldn't act just we shouldn't be launching a full invasion of a country just because there has been a cyber attack. So how do we consider proportionality in this case? So these are some interesting things that you could talk about in your classrooms. And we indeed see cyber conflict in the actual world. For example, the Russia-Ukraine war. Russia has been carrying out cyber attacks. And it's not their first time. There have been prior operations in Estonia and Georgia, including a massive denial of service, and there have been attacks against government websites, banks, critical infrastructure such as power supply, telecommunications such as the VisaSat satellite network, which supplies internet, and more. If you look at the figure 2, you see a majority of the Ukraine cyber objectives targeting Ukraine in 2022 focused on disruption, but there was also espionage and degradation involved. Ukraine has also been focusing on improving its cyber defense and resilience, including partnerships across governments and industry, such as US Cyber Command and Microsoft, and so on. So cyber conflicts and attacks are actually being used in wars and in international conflicts today. So moving on to ethics and case studies. You may be asking why talk about ethics. Well, first, technology is rapidly evolving. For example, we saw ChatGPT being launched in November 2022, and we've seen a huge change in the technical landscape with generative AIs and large language models, LLMs, in the past 2 years. And oftentimes, legal regulations lag behind technology. For example, there is still no international or even nationwide privacy law. The closest is European Union's General Data Protection Regulation, or GDPR, but there is no international agreement or a nationwide privacy law in the US. And for example, another example is the White House blueprint for an AI Bill of Rights in 2022, which talks about the 5 pillars for responsible design and use of AI. But this is non-binding, and this is pretty belated considering that AI has been around for already such a long time, and this was only introduced in 2022. So ethics is important to talk about because legal regulations still lag behind and technology is rapidly evolving. So sometimes we can't rely on legal regulations to make a decision, but we have to think about ethics. So ethics is basically what is right or wrong, and there exists outside of personal ethics, there exists professional code of ethics to guide cybersecurity and computer professionals. An example is ISC Square Code of Ethics. Another example is the Association for Computing Machinery, ACM Code of Ethics, which talks about computing professionals' actions change the world. To act responsibly, they should reflect upon the wider impacts of their work, consistently supporting the public good. And as I mentioned, it is important to consider ethics along with legal frameworks. For example, ethical penetration testing and bug bounty hunting, in addition to the legal frameworks that are posed for ethical penetration testing and so on. So there are 2 case studies that I want to talk about. One is the Apple FBI encryption dispute. And basically, this deals with the question, can courts in the US compel manufacturers to assist in unlocking cell phones whose data are cryptographically protected? This was a court case in February 2016, and the FBI wanted Apple to help unlock an iPhone 5C from a suspect involved in the December 2015 terrorist attack. The phone was recovered, but it was locked with a 4-digit passcode, and after 10 failed password attempts, it was set to erase all the data, but Apple declined. And this was basically Apple's argument and FBI's argument. Apple used the argument that while we believe the FBI's intentions are good, it would be wrong for the government to force us to build a backdoor into our products. And ultimately, we fear that this demand would undermine the very freedoms and liberty our government is meant to protect. You can read their full position in the customer letter, but basically this was their stance. First is the FBA argument. They used the All Writs Act, and basically this act is a pretty old act that talks about how all companies or people need to that it is legal to issue all writs necessary or appropriate in aid of their respective jurisdictions and agreeable to the usages and principles of law. So this is the act that they brought up in arguing that, hey, we need Apple support in decrypting this phone. And a classroom idea could be discussing, do you agree with Apple's claim or FBA's claim? Why or why not? And a second case study could be Stuxnet. This was done on a more international level. So this would be an international law case study, whereas the first one would be a domestic law case study. This Stuxnet is a malicious computer worm first uncovered in 2010, and it is actually regarded as one of the first cyber weapons. And it's so significant because it shows cyber attacks spilling over to the physical realm. And Stuxnet is very sophisticated, exploiting at least 4 zero-day vulnerabilities. And it also went out into the loose. It spread out of the attack targets. That's how researchers discovered it and did research into it. And Stuxnet targets the nuclear facilities in Iran, specifically the centrifuges for separating nuclear material. It changes the speed of such centrifuges, causing it to fail in what it's actually supposed to do. And while neither country admitted it openly, the sophistication of such an attack made researchers attribute it to the US and Israel federal governments. So I think some questions that we can talk about is how does Stuxnet change your perspective of cyber attacks and warfare? One thing I brought up is that it shows how cyber attacks spill over to the physical domain now, right? Another interesting topic to discuss would be what are some international regulations we need surrounding cyber attacks? And going back to the question in a previous slide, is traditional international law adequate to address cyber attacks and cyber warfare? What are some gaps? And here are some more discussion topics, such as ethics like hacking back, the role and scope of government, such as key escrows and backdoors and civilian surveillance, whistleblowers, free speech and content controls, data breach, copyright, and the ethics of AI. Finally, here are some key takeaways from today's video. Some key takeaways are one, there are domestic and international laws regarding cyberspace, and some are derived from traditional laws such as the Fourth Amendment and jus ad bellum and jus in bello international law concepts, whereas other focus more specifically on cyber, such as the Computer Fraud and Abuse Act or CFAA. And the second part is we need to consider ethics along with legal requirements, what is right, what is wrong, since laws often lag behind technology. And third, there are interesting discussion topics within cyber law and ethics, including actual case studies such as Apple and FBI encryption, to high-level or topical discussions such as the need for a nationwide privacy regulation. And with that, I will end my presentation. If you have any questions or comments, feel free to reach out to us at other@picoctf.org. And thank you so much for listening.